A brief pause. Though it might not seem like much, harassing communications is a serious offense in Texas that carries a jail sentence. Observe how the court emphasizes that harassment includes calls and texts from several numbers. What are your thoughts? Is jail time really necessary for persistent texting following a breakup, or is it going too far? Tell me in the comments below.
Good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that night she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we talking like tons of text and stuff? How many are we talking?
Sure. Tons of texts from different phone numbers after the complainant had repeatedly told him to stop.
What did you manage to capture? Simply put, the judge stated, "I don't care if it's a smoke signal." That's trial jargon for no justifications. Although hearing a judge use humor like that is actually rather uncommon, it serves as a serious warning. You'll go straight back to jail if you break this order. Consider jeopardizing your liberty merely to send a Snapchat.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's with Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond to put you in jail. Do you understand?
Sir.
No means no. Just, you don't have children with this person. Move on. There's 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right?
Sir.
All right. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you have the ability to hire a lawyer?
Yes.
Okay. So what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Please. Good morning, Mr. Runyon. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 23rd, 2025, a witness stated that he saw the defendant dump a sofa on the 22800 block of Fair Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant. The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location, so the witness drove to the main roadway near his house and observed the sofa had been dumped at an abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road. Yeah.
The witness stated he was cooking, looked out his kitchen window.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
Sir,
Right?
I would just request, this is not with us, this is with environmental. I would just request we hold off on PC ratings until the prosecutor hears the case.
Okay, I mean, I'm willing to hold it, but, you know,
I get it. I just want to make sure the prosecutor.
Mr. Runyon, just take a seat for me in the jury box, please.
Morning, Judge. I have a gentleman by the name of Kayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless he does, and he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about
Okay, gotcha. Would you like him brought up,
Just-
Judge?
Please.
Okay. Mr. Thomas?
Good morning, sir. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Gary Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and the defendant then exchanged in a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here, you better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at the location speaking with the complainant's coworker.
At this point, everything starts to go south. From texting in couches to outright gun threats, we've come a long way. It's more than just a dispute. That constitutes a terrorist threat, which is punishable by law in Texas. Also, take note of the judge. He is meticulously focusing on determining whether a single threat is sufficient to establish probable cause. What are your thoughts? Should someone's life be destroyed by a single violent outburst, or must the system adopt a strict stance?
Who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have his.
Remember, this is a probable cause.
I
To
understand.
start getting into more stuff, I mean, my only concern is, was there a terroristic threat, right?
Exactly.
And I don't know, it looks like there were potential multiple threats, so which one is in the charging instrument? Is
I think the one alleged to have occurred
on the actual day in question when everything,
I can look and
Yeah.
double check.
because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, you know, he had told them, don't upsell me, don't upsell me. He comes around the corner and the guy's in his car. So that's why they gave him the discount on this.
but I mean,
Even so,
Did-
Your Honor, a discount was a discount when it happened.
No, I understand.
And just to clarify, it is the first threat on
first
February
threat.
18th.
Yeah, I mean, it's,
It is what it is. I understand.
so, Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness, don't be in possession of weapons, and don't go back to the 5-minute
5-minute oil change.
Yes,
the
sir.
5-minute oil change. That's all I'm asking you to do, really. Just don't have weapons and don't go back, okay? That's it. As long as you can.
Also ask for no contact with the complainant to visit the
Of course.
We'll fix it. Already. Anything further, Judge?
We have to do bond.
Oh, I'm sorry.
Am I putting me on a PS? Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to. All right. So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and just, that's it.
Okay, thank you very much.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with Fleischer for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, Judge Powell, do you
Yes, sir.
attorney record, please?
Yes, sir,
We
certainly.
have him over there in the tower.
Okay, thank you.
Judge, I need a quick question.
Sir, you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and/or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right for trial.
Sir.
Held witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
¿Quieres en este convenio? Yes.
Is it true
¿Es
or
verdad
untrue that you
o
had
no
a
es verdad
five or above?
que tenía un 2.5 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí,
¿Verdad o no verdad?
verdad.
True.
answer? All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
¿Lo entiende?
Yes, sir.
All right, good luck.
Thank you, Judge. Have excuse.
Thank you.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardan.
Okay.
B-A-R-D-A-N.
So you got appointed Mr. Albardan?
Yeah.
Great, okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's Mr. Albardan. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right, I'm done.
Thank you, Judge. I'm excused.
The only, Mr. Albardan, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, ma'am.
Okay. All right. Thanks. And if you can file, no, now we need, yeah. So Mr. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no threatening and harassing.
Right there, not to leave.
Okay. Stacey.
Last name is Bledsoe.
Bledsoe. Okay. You want to bring him on? Are we going on the evading and the terrorist threat? That's going to be dismissed. Good morning, Mr. Bledsoe. You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, and give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Good, sir.
I'm going to find you guilty. I'll sentence you to the agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna, we have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are,
Sorry.
it's okay. No, and I think you're right. We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to. I want to stick with the agreement that the county came to with the district attorney's office,
So, not saying it's this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
Here's my question for the board, and I'm not saying I'm gonna do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, let's say we can't take it to grand jury?
You can, of course you can.
So,
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, I'm just, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you did.
Oh, really?
I just, so we wouldn't be held to that same standard at grand jury.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is.
This is required for them.
I understand.
Just good.
Thank you.
God love you.
Good morning.
Is it?
Yes, sir.
All conditions will continue. You are not to use. Do you understand?
Yes, sir.
I will test you again in about 45 days. If you test positive again, it's not going to go well for you. I'm not asking much. Do you understand?
Yes, sir.
Okay. All right.
And
That's
we
it.
are doing, we're working on a PTI with the,
The quicker you get it done,
that's what I'm saying, with,
quicker it is for you.
they do want to test as well as a condition, so Once we test him again, then we can submit.
You hold the keys to the jail cell. No one else. Do you understand?
Yes, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
Thank you.
Yes, Your Honor.
I'm gonna find that there's no probable cause to go forward in your case. Aren't our streets dirty enough?
Yes,
Don't say anything, just please,
understand.
keep it nice.
Yes, sir.
All right, please.
Thank you.
Please.
Hey, Judge, may I approach?
So you got something interesting?
Oh, we were going over, on this case, we were talking about if a private citizen takes somebody's car key and seizes somebody and holds them there till the officers show up, is it allowable or not? And so,
Well, it would have to be a felony or a breach of the peace, right?
right, it would have to be one of those, because otherwise, it could, I was telling them it could be argued it's fruit of the poisonous tree, it's an unlawful seizure. And so if it's a government action, it's.
I thought you were getting more toward a, like, kidnapping.
Oh, no, to like say it's an unlawful seizure, like, there's, we were comparing versus, it's not because it's a private actor, but I'm saying, hey, even if it is a private actor, if it effectuates what a cop would be doing, it would fall under the same tenets of unlawful search and seizure, and so.
Certainly interesting.
Yeah, I don't think we're gonna get there, though. I don't think we're gonna get there on this one. I don't think we're gonna get there on this one. It's,
Theory's wonderful,
So,
You got it.
Mr. Lázaro Echemedia.
H. It's old.
Yeah.
What do you want to do?
So we're set to plea or set it for trial today.
Correct.
I see some issues in the case. I've talked to my client. He is interested in possibly doing something different, but he is,
I mean, what other
we
difference?
need an immigration consult, well, possibly time served. But the thing is, the holdup is, I need an immigration consult.
That should have been done beforehand. I mean, today we're set plea or trial. This is not.
Right, and the only thing is,
We're now 215 days.
the thing is, I was only appointed like a month ago. I saw all this issues over the weekend, and so talking to him, see if he wanted to go to trial, he's like, hey, hold on, let's get an immigration consult, see how it's gonna affect me, so.
Okay, so I guess I'll give him till Monday.
The only thing with that is, Judge, this consult goes through the MAC. It's Miss Julie Pash. Today is Thursday. She's been getting on me about how backed up she is lately.
It's 215 days old. I mean, it should have happened a long time ago.
Right.
You can't just, it's on him. It's not on you. It's on him.
Yeah, I'll be straight with you, Judge. I don't know why I was only appointed like a month ago. I don't know if he was missing or something.
Correct.
was
He's been AWOL for all that. So it's not, I mean, I'll give you a week, but that's it.
Okay, I'll let her know. I'll let her know, and hopefully she gets it done. Thank you, Judge. All right. Okay, cool. Thank you.